All right, looks like we're going live. Just waiting for it to enable. Yep, great. Looks like we are streaming live on 4 different platforms. So that would be YouTube, Rumble, LinkedIn, and Facebook. So if you guys are on any of those platforms, if you want to cross-check, just see if we're coming through loud and clear there. And I want to welcome everyone. Welcome, everyone. Of course, it's Independence Day here in the United States. So, but really, independence. Is it not a state of mind? Is it not something that we can experience anywhere? So, I think it's very befitting that we're meeting today. That's kind of the background, and I'm very grateful to have to co-host this collaboration with Standing on the Rock. You guys are in for a real treat today. We are going to, with the help of our co-hosts, we're going to dive in deep to the principles of equity, but we're also going to take a look at what can actually be achieved when you start to employ these principles. And so, in the backdrop of independence, it might be worth thinking how would your life be different if you were able to start embodying these concepts and using them in your own life? That's what I want to invite you to explore as we go through the presentation and what's going to be shared today. Having said that, I'm going to go ahead and hand the presentation over to Julian, and Aaron is also going to be helping as well. And I'll just be here in the background, keeping an eye on things. And in the meantime, while we're going through the presentation, you can queue up your questions or thoughts in the chat. There will be time later on after the presentation for you to unmute yourself and ask questions. So, does that sound good to everyone? Amazing. In that case, Julian, over to you.
All right. Thank you so much, David, and to the Freedom Studio for facilitating this wonderful gathering today. And we'll go ahead and show some great testimonies today after we talk about the principles of equity. First, I'm going to bring up our slides and just speak a blessing over today, and then we'll get into it. Well, and also happy birthday. Happy 250th birthday to America. Lord God, thank you so much for this gathering today, and thank you for the 250 years that we've marched forward as a nation. This message today may, to some, sound like the voice of Jonah crying repentance unto Nineveh, and to others it may sound like the voice of Zechariah defending the city of Jerusalem with fiery walls. And to others, it may sound like the voice of Joshua speaking to Jericho. But let it not be so, Lord. Let us heed the words of Jonah, repent, and turn towards the path of Zechariah's Jerusalem. For as God said in the book of 2 Chronicles, if my people, which are called by my name, shall humble themselves and pray and seek my face and turn from their wicked ways, then I will hear from heaven, and I will forgive their sins, and I will heal their land. Let it be so, Lord, and use this information to heal our land, that we may walk forward with you into a glorious new future of freedom and independence, once and for all. In Jesus' name, amen. All right. Thank you so much for being here, everybody. I am Julian Swan, and this is a picture of me here and my beautiful wife, Margaret. We are the founders of Standing on the Rock Ministry and School, where we teach equity and trust systems. Again, thank you all for being here. We want to give you a good overview of what we're teaching, and we're going to look at a bunch of testimonies and some actual proofs, some actual screenshots of proofs. some receipts and some official letters that were received by our students, and some actual testimony that they sent to us on Telegram. And at the end, we'd be happy to take all the questions you can throw at us. All right, let's get going. So we could say that equity serves as a correction to the rigid legal formal approach of common law or maritime admiralty commercial law. Equity asks not just what the rule says, but whether the result is fair in conscience. And that idea of conscience is incredibly important in equity. By focusing on substance over form, or rather spirit over rule, equity will help prevent injustices and make remedies like specific performance available, especially where other legal remedies fall short. Equity gives a judge a broad discretion to go outside the confines of the laws. How many of you, applying your constitutional arguments or common law pleadings, have heard a judge say, "Well, I'm bound by the rules of the court of Arizona or whatever. I'm bound by the rules and procedures of the federal district of whatever." Well, that is true. However, equity allows a judge to go beyond that, to seek a more fair and just remedy than that which is available at the strict law. And anywhere that equity is listed, like in the Constitution, it'll actually distinguish equity from law. It'll say equity and law or equity or law. You can see this across many acts of Congress and Parliament, depending on where you live. And it's always distinguished from the law because it's really um, the highest we strive at perfect fairness and morality in the law. That's the entire purpose of the law, right? Is to provide the most just outcome. And of course, we can go very far down, thousands of years of statute and common law procedures, but ultimately, this began to be kind of a stranglehold on justice. With so much rote formality and required procedure, it began to get very far away from just the individually tailored solutions that people needed. And so that's where equity came in. Equity came in to provide a higher morality. And for that reason, it is the highest and most powerful jurisdiction. But it must be applied in a very specific way. It's very easy to leave equity if you're not staying in it. Of course, it came from around the 13th century in England, and now many countries around the world base their law on English jurisprudence. Any country which you look up and it says that it's a common law jurisdiction, you can just know that equity is automatically included in that. Most of our students are from the United States, but we have many students from Canada and Australia and the United Kingdom, Ireland and South Africa, New Zealand, and many other people interested. Uh, Equity is available in some pretty wild places. Like you could go to Abu Dhabi and expect to find equity there. It is actually a system of English jurisprudence which they use. So all over the world, in the Caribbean and the Pacific Islands, in Central and South America, even in West Asia, you can find equity everywhere, just readily available. And then there's many other countries which, while they don't have a formal system of English jurisprudence, there's been some kind of mixed in. You can find elements of equity in Japan and many other countries, Israel, for example. So we actually have an interactive map being developed on the website, which we'll talk about in a little while, where you can just look your country up and see how applicable what we teach is. It's going to be applicable in basically the entire Western world. Um, but if you're in a civil law jurisdiction, there's just going to be a little bit of different application. Anyway, it comes from 13th century England. It actually came out of the church. It's the only jurisdiction of law entirely based upon the Word of God. Common law, of course, draws some from Greek and Roman influences. Most civil law countries come from Justinian law, which is like kind of a late Roman Empire version. But they've mixed in elements of equity all throughout the world. In the modern day, equity and law have been merged procedurally, and you can actually, you can look that up in Blacks. Procedurally, they're merged, meaning they're in the same court, but there are two different streams available to you in any court in the Western world. You do not have to be in a chancery court in order to receive equity. You can receive equity in any court, and we've done it hundreds, if not thousands of times. Equity's always been our roots in America and of course across the Western world. We focus on the Constitution today because it's America's birthday, and of course, Article 3, Section 2, Clause 1 specifically lists equity as a power that is available to all cases. But this is fully backed up no matter where you are in the Western world. So long as your country descends from English jurisprudence, as I said, it's readily available, and even in many civil law countries, what we do is quite applicable. Common law does fall short in many occasions. Um, Here are a couple of maxims from what we call the Book of Wisdom, which is Burton's legal thesaurus. And though Burton's is just a secondary source, and we walk you through quite a lot of primary source material in the class, it is a very useful resource. So the first word is custom, and you see a couple maxims of law. A maxim is just something which sums up many hundreds of years of case precedents and judicial decisions. It just sums it up into one kind of pithy sentence. So here it says custom supersedes the common law, and there's another one that says custom overrules the common law. Well, what is a custom? A judge just makes up a rule for their local area, and none of the attorneys challenge them on it. And why would they? Because they want to stay on his good side. And it becomes a custom. And custom is just a repeated practice over time. And actually, custom becomes a sort of law in and of itself, and it's a higher law than common law. So unfortunately, when you bring common law pleadings in certain courts, they have customs which overrule, and the judge doesn't tell you the customs. There's nowhere you can go and look up the customs. Occasionally, I've seen it on a court website, like they'll have a list of local rules, local custom, but it's very rare to find it written out. Usually, you just have to have been practicing there as a statutory attorney for a while, or be a clerk. Maybe if the clerk's having a good day, they might tell you about a couple of the customs, but it's typically not even disclosed. It's just you just find out. So that's a problem if you're bringing certain common law pleadings, because you may find that the local court simply has a custom that overrules anything you're trying to do. Next word is consent, and we have a couple maxims again from Burton's. No injury is done by things long acquiesced in, and persons who consent and those who perform are subject to the same penalties. So, I mean, there's a lot of people that try to say, "Oh, well, I'm going to rebut the presumptions, and it wasn't a valid contract. The birth certificate contract, the Social Security number, estate, whatever." And you may have a point, but the problem is that when you try to argue that, all you're doing is bringing yourself under their jurisdiction. You're creating controversy, and controversy will give the judge full authority to adjudicate over your life in the full extent that statute allows him to. Why is this? Well, the courts are the one venue in all the realm where controversy goes to be adjudicated over. It's one place where you can, one person can agree or disagree with another person. That's a controversy. They bring it to the court. The judge becomes the daddy, and he rules over the matter and can inflict specific performance requirements on each person. So when you go into the one venue in all the world that was created to eliminate controversy, and you start raising a bunch of controversy by disagreeing with the other person and arguing with them, then you have already lost. You're going to be under Admiralty Maritime Commercial Statute, and that is a brutal law form. I know people that have argued for 15 years in a foreclosure case, and wonderful. I mean, they did wonderful. They acted like attorneys, and they did the attorneys' jobs better than the actual $100,000 attorneys that the bank put up against them, and it still fell short because when you're in Admiralty Maritime law, they always have another trick up their sleeve, and even when you're in common law, inevitably you wind up arguing against their admiralty maritime statutes. So anytime you're in the middle of a controversy, they always have a way of getting what they want. When you try to play their game by their rules, you try to beat them at their own game. It does not tend to work out very well for people. It's very, very rare that anybody sees remedy that way. When you stay in equity, you create no controversy, and we teach you how to go to court without falling into their contracts. So, and just to speak to the actual contracts that you're rebutting the presumptions of, or that you're claiming don't apply to you, you've acquiesced for quite a long time in that role as surety for the all caps name and the birth certificate account. You have consented for quite a while, and you have performed for quite a while, and so you are subject to the same penalties as somebody who consented from the very, very beginning. When you use that social security number to open a bank account, to get a driver's license, to fly on a plane, to rent a car, you are performing, and so you are treated to have consented. Doesn't matter if you didn't find out till later, they are going to assume that, and when you try to argue about it, then you've just stepped into their trap. So we're just going to not even worry about any of that. We don't play the name game in equity. We don't rebut the presumptions in any direct way. We do have a few indirect methods, but for the most part, we just bring equity and let justice be done. And again, we have seen it hundreds, if not thousands of times. This is just a brief slide about the difference between conditional acceptance, which is something that's very popular, and then the unconditional acceptance that we use in equity. In equity, we just accept. We don't care what they're charging us with. We don't care what the payment claim is. They could say we owe $1 billion. It doesn't matter to us. We just accept. Now, of course, we're not consenting. The acceptance that we use is more of an assent rather than consent, and it's more of an accounting term. And so we can get into why we do that later. But that's a very important concept in equity, and of course, acceptance is an attitude as well. It's a frame of mind, and it is a spiritual concept. But it just so happens to also be an accounting concept. It's very interesting. If you look at these are excerpts from the UCC, and then of course in the bottom right we have the Canadian and Australian equivalents. And of course, we could show you the UK equivalents too. I mean, it doesn't matter where in the Western world you're from. I just wanted to show some parallels so you know that it's pretty much the same. It's about 95% the same process, no matter where you are. And that other 5% we've done our due diligence on getting you there. So this is just showing a couple excerpts from the UCC showing that when you accept a draft, it must be unconditional. And the holder, which is the person that you are returning your acceptance to, they can refuse it if you have quibbled with them or negotiated with them about any of the terms involved in what they were offering you. So conditional acceptance is refusable by the other party, and that's why it is the success rate is quite lacking compared to just unconditional acceptance. All right, so how does this tie in? Well, courts in the modern day have been brought under the same modern monetary theory that the central banks have pushed upon every other institution. Um, Now we can look at the definition of bank here, and this is from Black's sixth edition. It says that a bank is merely, the bench of justice, the seat of judgment, or just a court. I mean, they just come right out and say it. There's so much crossover between finance and the court system, and a lot of people go after the bonds and look up the CUSIP numbers, and that stuff's fine. I mean, it's all true. I think some of the methodology is a little bit lacking, and we teach you a better way in the equity class. But what all that serves to do is highlight the commercial relationship between the individual, the defendant, and the court. The court derives financial sustenance from the participation of the defendant. So you already have a well-established um, financial relationship with the court. The court actually has a financial interest in every case that it oversees. And there's Supreme Court cases which actually back this up, which we talk about in class. So the courtroom is not only a place of adjudication, but it's also where obligations are calculated and assigned and enforced using commercial administration. The language itself just points in that direction. You know, the bench is the seat of judgment, the liabilities are imposed, debts are recognized, and payments, fines, and costs are used to satisfy what the system says is owed. So in the class, we explore in depth how judicial administration doesn't merely use commercial language, but also operates through financial instruments and accounting structures. They kind of do this right out in the open. The accounting happens behind the scenes, but all the terms that they use in the open kind of signify this, and there are things that we can take advantage of if you understand the accounting processes involved. And of course, you don't come into dispute because that would put you under a general appearance or under statute. We do so in equity, and that allows us to avoid recontracting with the court and simply help settle the matter in an accounting uh, and settlement. And here's some of the terms that are used in a court, either openly or surreptitiously. A draft is a very special type of financial instrument that specifically invites acceptance. And it turns out that many things fall under the definition of a draft. Now, this is just a basic definition from Black's, but when you go into primary source materials about the origins of drafts and how banks actually use them, there's about 7 or 8 defining characteristics of a draft. And this actually has quite a broad reach. So we dive into the fundamental aspects of these financial instruments and help you kind of just build from the ground up an understanding of finance. You know, finance is in the modern day, for most people, a very confusing thing. It just doesn't seem to make sense for most people. Most people, they just gloss over when you start talking about, the monetary system and how power is really enforced upon the masses. It's all through financial instruments and financial relationships and security interests. So we will break down the fundamental concepts of each of these things and kind of help you understand their individual components from a foundational level, and then we build you up in that understanding to where you're starting to think like a banker. You're starting to think like a member of a wealthy banking family, that's actually raised in this and taught this from a young age. We kind of will help you bridge the gap there, even though you're coming to us later in life. So there's a number of different financial instruments at play in court. These are just 4 of them, and we give quite a robust education into these matters in the class because these are all things that we can take advantage of. Because the court has been forced into the modern monetary system, the court also has to play by the central bank's game. And when everybody dances to that tune, it's something that it's every institution does it surreptitiously and then presents a different face. The face that they're presenting is kind of the way the world was before the central bank. You owe this, you have to pay, you're hurting somebody if you don't pay. You've committed this crime, and we are empowered by Congress or Parliament to enforce a punishment upon you. Now everything runs through the central bank. Doesn't matter where you are in the Western world. Courts no longer have the mandate of Congress and Parliament in quite the same way that they did in the past. Now everything is commercial. Everything runs through the central banking system, and no matter whether it's a civil or a criminal charge, the accounting is handled the exact same way. Um, and what's more, the debt is actually used to pay for itself. They actually create the asset and the liability on their books at the very same time whenever they loan you something. And the idea that you're somehow hurting somebody by not paying it is a concept that really hasn't been in play for almost 100 years. Now, at the same time, we actually pay for everything in equity. You actually remain in full honor. And this is because of our understanding of the financial mechanisms involved. We can exploit that to get them a payment instrument that they can actually use at the central bank, and they do actually cash it in. So you are actually paying when you pay in equity. We don't get out of anything. We're just using their laws in their modern system to pay in the way that they have reserved for themselves and that they did not teach us about. We had to figure it out. So the goal is to move from vocabulary to structure, and then from structure to practical understanding. Once we understand the terms, we can begin to see the sequence, the offer, then the instrument, then the presentment, and then either honor or dishonor. And we wrap this solid financial process at work in the world over a framework of equity where we use the art of inquiry to compel discharge. Equity can treat obligations and interests with a kind of temporal flexibility. Equity may regard an obligation as already fulfilled when it ought to have been fulfilled. Equity does what ought to be done or what ought to have been done. That's a maxim, which works consistently with the law rather than outside of it. The remedy operates directly on the conscience and on the very conduct of a person. It doesn't just award damages; it can actually, compel the person to do something for you. Now, the phrase that equity time travels, this is just a teaching device. We're not suggesting some kind of fantasy here. We're just describing the way that equity can move through time as unbounded in order to secure the most just result. For example, in equity, the court may treat something as having been done from an earlier point than it actually was in reality. If conscience obligates that it ought to have been done earlier and the intention was there, then the court can see it that way. It's a sort of a legal fiction, but it's a legal fiction striving at what is most conscionable. So it's within equity as opposed to most legal fictions, which are within statute. The idea is captured in the maxim, equity looks on that as done, which ought to be done. And the point is that equity does not need to always wait for formal verification if some duty or some obligation already existed or some moral compunction already existed, and justice requires that the parties be treated according to that prior obligation. At the same time, equity is not lawless or just totally detached from legal order. There is a maxim that states that equity follows the law, which means typically in the past, you might have needed the law to kind of run out of remedies before equity could be brought. In the modern day, it just means when the law messes everything up, equity comes in to clean up the mess. And there's a third maxim, which is equity acts in personam. And this explains how equity is able to do this. Its force is directed towards the actual person themselves, towards the conscience and the obligation and the conduct of the party. So the court can compel specific performance from an individual as opposed to just awarding damages and working on property. The court can restrain misconduct or protect earlier equitable interests by acting upon the individual person rather than on property. So when we say that equity is not bound by time, what we really mean is that equity can look backward to the moment an obligation arose and forward through later events in order to recognize and protect what fairness said should have already been honored. Equity may treat an act as effectively completed when it ought to have been completed. And what this means practically for you is that when you learn our methods, it's something that happened 20 years ago can be cleaned up as if you're right in the middle of it. If you have a charge that's sitting on your record from 20 years ago, it can be cleaned up. You can compel it to be wiped clean. You simply need to bring the proper honor to it, and the system will let it go. There's also, say you've had a tax presentment sitting on your desk for the last 2 years and you've just kind of been scared to deal with it. Well, once you take our class, you'll know how to handle it and you can treat it as if it just came in the mail yesterday, and the tax agency will honor it as such. There's also the power of equitable rescission, which is another method that we teach. It's a very specific application of the doctrine of rescission. And of course, equitable rescission is far more powerful than commercial rescission, which can only be done within 72 hours. Equitable rescission can take something that you got yourself into, say, 30 years ago, and unmake it as if it never existed from the very beginning. And it is actually stronger than an annulment. An annulment is a statutory reversion of fictional status. For example, like a marriage annulment. Well, it was a fictional marriage to begin with because it was in statute. The state has no business supplanting the will of God and acting as God in marriages. It's only because we're under war powers that the state even feels it has the ability to license marriages in the first place because it's like they treat it as commercial conduct. Um, so you can actually be bound that can actually create kind of an adhesion contract, and we can unmake that and bring the marriage back under God, and remove the adhesion contract that is allowing and empowering child protective services to get involved, or certain support payments to have their legal weight, so long as the moralities of the situation are fully respected. Then we've helped many, many people with those kinds of issues. All right. So how many of you have felt that when you went to court, there was something spiritual going on? I mean, the judge is wearing a black Saturnian robe, left over from thousands of years of ritualistic practice. You have Lady Justice up there with her blindfold and her sword, and she is of course a modern personification of a Roman goddess, which they just took from a Greek goddess, which they just took from an Egyptian or a Babylonian goddess. So it's something that's been repeating itself for thousands of years, and you can just kind of feel it in the air when you go to court. I mean, even if you are unlearned in spiritual matters, uh, I believe that everybody kind of has a sense of those things. Well, it's very important to understand certain spiritual principles when you go to court, and not in a religious way, but just in a manner of the Creator imbued this universe with certain laws and principles, and when you align with those things, you'll see that doors open up for you, and that doors close for your adversaries. So there's some very important spiritual concepts that we get into the class. Um, there's Bible passages which show a direct chain between the heart and the mouth and the outcome of a person's life. What we say matters very, very much. Proverbs tells us to guard the heart with diligence because the issue of life flows out of it. And that means the heart is the source. If the source is neglected, then the words and the attitudes and the decisions that flow from it will also be affected. And in the class, we talk a lot about intention and not expressing verbally doubt and fear. In our experience, it makes a huge difference. It's the difference between losing and winning, between incarceration and freedom, and truly between death and life. Proverbs 18:21 says that death and life are in the power of the tongue. And that is a profound warning and a profound opportunity because it means that our speech is not neutral. Our words can either reinforce fear and defeat and corruption, or they can reinforce truth, faith, blessing, and life. Jesus makes the connection even clearer in Luke 6:45, where he says that out of the abundance of the heart, the mouth speaks. In other words, speech is the overflow of inward belief, inward meditation, and inward condition. And that is why Matthew 12:37 is so serious, for it says that by our words we are justified, and by our words we are condemned. And that gives deep significance to the power of what we say. And of course, the courts are based upon the Bible. Many of the modern statute and admiralty maritime practice comes from Roman ecclesiastical law. And of course, equity is always present as well, which is entirely based upon the Bible. So these verses carry spiritual significance in that they're pointing at laws that can lead to either death or life. So we need to make sure that we understand what they are. And the point is not merely that words are sounds, but that words testify to what is established in the heart, and eventually they shape our conduct and our relationships and our consequences. The practical lesson is that if we want to change what's coming out of our mouths, we have to first deal with what is living in our hearts and our minds. Our thoughts shape our beliefs, and our beliefs shape our words, and our words shape our actions, and our actions shape our outcomes. That's why it's so important to speak positively and truthfully and in faith over our situations. not as a mere, affirmation or an empty denial, but because disciplined speech is rooted in a guarded heart, and it aligns with our inner life, and our pursuit of wisdom. Over time, this does change how we act, how we respond to, potential attacks or challenging situations, and then of course it'll influence the fruit that we produce. So our words carry real power. And Scripture warns us to watch both our hearts and our words because life and death, justification and condemnation are all tied in to what is within us. If we want different fruit in our lives, we must begin with the root, our thoughts, our beliefs, our hearts, and then bring our words into agreement with truth and life. One of the things that we do with these classes is to give you a solid framework to hang your beliefs upon, to strengthen your faith in remedy, to know that there is a remedy available, and that you can be secure in that because we take you into the primary source materials and show you from the same acts of Congress or Parliament or the same books of law that the judge is relying upon, um, why our acceptance compels them to settle and close the matter and drop it and leave you the heck alone. And so long as you embrace the path of peace and honor, you will be left alone. So these testimonies and these primary source deep dives and the testimonies of our students, these things strengthen us and they give us a foundation to hang our faith upon, and then we can start speaking out in that faith, and then we can start seeing the fruits of the results. All right, and this just gets into some more foundational scriptural principles. First Romans 12:2, it says, do not be conformed to this world, but be transformed by the renewal of your mind, that by testing you may discern what is the will of God, what is good and acceptable and perfect. And this sets the foundation for the whole course. Real change begins with the mind. If the mind is renewed, discernment becomes clear, and we are less likely to simply react according to the ingrained patterns of this world. We're all raised in a system that teaches us to be combative, or that teaches us to comply. It's pretty much either comply or be combative. And there is actually a third way. You don't have to simply knuckle under or fight. There is actually a path of soft power through peace and honor that compels performance far more powerfully than any attack ever could. So we never consent. We never simply roll over. We never raise a fist or a stone either. We know a third path that we can impart to you that will get results far quicker and far more easily. Next is James 1, verses 6 through 8. He that wavers is like a wave of the sea, driven with the wind and tossed. For let not that man think that he shall receive anything of the Lord. A double-minded man is unstable in all his ways. And this warns us that inner division produces instability. If the mind is not settled, the person becomes inconsistent in their thoughts and their speech and then their actions. And that instability affects everything else that they do. Excuse me. Again, it starts with the mind. When the mind has two conflicting patterns, two conflicting ideas, the mind is at war with itself. And this begins to manifest in every other aspect of your life. So the book of James warns us very starkly against this. When your mind is at war with itself, you cannot receive anything from God. And God is constantly trying to pour out his blessing upon you, but you will not receive it so long as you are standing on a shaky ground and an unstable foundation. So we must bring our thoughts into alignment with the power of life and understand that God has provided a remedy for us. We cannot mix processes, either mentally, spiritually, emotionally, or legally. Equity can't be mixed with anything either. So at all levels, we must be consistent in our approach. All right, and then Matthew 5:25, last scripture for today. Very important. Agree with thine adversary quickly, whiles thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. And acceptance is agreement. It's a particular type of agreement. It's takes advantage of the modern system and the accounting term of acceptance combined with the actual spiritual act of agreement or acceptance, as defined by Matthew 5:25. It teaches the wisdom of resolving matters early while there's still room for peace and clarity and voluntary correction before the matter escalates into judgment and restraint. The process of equity teaches us how to accept offers in agreement rather than arguing or bringing controversy. And we should do so quickly. We should agree quickly. And if we can do that, then we will see the best outcome. Of course, equity will be able to be brought at any point in a case. The sooner the better. But equity corrects errors. Equity does what ought to be done or what ought to have been done. So you can bring equity at any time, but the sooner the better. Taken together, these scriptures form a progression. The quote from Romans tells us that the mind must be renewed, and then James tells us that the mind cannot remain divided. And then Matthew shows that a sound and disciplined mind responds quickly and wisely before conflict matures into bondage. So the thread connecting them is this: transformation begins within, stability must be maintained from within, and what action must follow, and it must follow without delay. That is why these verses are foundational to the course. They speak to mindset, to spiritual steadiness, to proper discernment, and to timely acceptance. All right, now for what everybody has been waiting for, the receipts that we promised. People ask us all the time for testimonies and for proof. So I'm going to show you some of that next. I can tell you that this is just a fraction of the successes that we have seen. We actually have a Telegram folder with many hundreds or probably thousands of posts at this point. We had our team comb through there and just look for some of them, and cases where equity has been used to bring discharge and get our students to be left the heck alone. And by that, I mean they got their freedom. So let's jump into these receipts. All right, first one is an IRS letter that was received by one of our students, and this is actually very common at this point. I mean, we see these testimonies rolling in quite frequently now. Now that our students have, we've had like a good few years to get going, because sometimes it can take a year to maybe 2 years to get an IRS matter discharged, and that doesn't mean you're just doing work constantly. It's maybe one or two things you got to do each month, if that. But this one rolled in within just a few months, so sometimes these matters are resolved quite quickly as well. This was received by one of our students. The first notice is an LT38, which is showing a balance of $157,800. That was on March 28th, 2024. Of course, he did not start bringing equity to this matter until I believe late 2025 is when he first found us. And the second letter is an LTR 96C, and it says, and I quote, "We received the information you provided and determined no action is necessary on your account. The current balance due for your Form 1040 for the tax period ended in December 31st, 2016 is $0.00, which includes interest and applicable penalties. Penalties. All right. So the tax period in question was 2016. He'd been dealing with this for almost 10 years. Started bringing equity in late 2025. And as you can see, this letter was received January 16th, 2026, and it's addressed to his wife. So it actually split his wife's balance and his balance into two separate amounts. They're both around $150,000, and they were both owed separately. So the IRS fully respects equity, and we know that because they always discharge the wife's debt first before the husband. There is a maxim of equity which states that equity prefers women and children, and of course, the rest of that maxim says and creditors most of all. But let's focus on the first part. the IRS fully respects equity, and so does the CRA and the ATO and the IRD and the HMRC and all the rest of them. These tax agencies fully understand the acceptance process that we use. And there's some convoluted aspects to it. Like you have to really read their letters carefully because they're indicating you that you need to do certain things. But when you know how to read between the lines of what they're saying and which of our tools to use in which situations, you can get fast results like this, especially for your wife. The IRS always discharges the wife's debt first, and so this was discharged, I think, within 3 short months, $157,000, and then the husband's debt came a bit later. This is the husband here. And he says, you're going to love this LTR 544C that we just received with an actual apology from the IRS for their error. Amazing how things have changed. So this is a guy that was arguing on and off with the IRS for 40 years. And we have an excellent testimony of him up on I believe on our website, on our YouTube channel. His name's Blake. And here you can see in their letter, they are actually apologizing to him. Um, we apologize for our error. If you have any questions, you can call us. Of course, we don't need to call them. The matter's done. And yeah, quite wonderful for a guy that's been fighting for 40 years. Once he embraces the path of peace and honor, they actually apologize to him. Pretty amazing. And here's another letter that Blake and his wife Angelina got. No further action is necessary on your account. And the whole thing has wound down now. This is from the Fresno office too, which they can be a little bit more aggressive, but even they are admitting that the account has been closed. All right, here's from a different couple, Dale and Renee. So the first letter is showing that they received a payment, and this is actually quite a bit less than the amount that they had claimed was owed in previous letters. But here the IRS is saying your account is paid in full at this time, and you can see that in the fourth line there on the first letter. This is actually after several acceptances. So what we believe is happening is that there's a stated amount that they're saying that we owe, and then there's a securitized amount behind the scenes. The IRS is a highly convoluted organization participating in some very complex financial dealings in conjunction with the Treasury Department. And so we believe that each of our acceptances is paying down the balance. And this was just the last amount that needed to be paid, this $1,712. And then they received another letter saying, we received the information you provided and determined no action is necessary on your account. So pretty wonderful. And then here is a lien that had been placed against Dale. And here is actually a certificate of release of federal tax lien. So this is showing that the lien was released, and the lien amount, if you see in the bottom right there, is for over $26,000, and that was for the tax year of 2014. And he had this sitting on his record for over 10 years, and finally brought equity to it. And this one came, I believe, within 4 months. So there you go, proof of a release of federal tax lien. And many of our students have received these. Here's one from our illustrious David Greenberg himself, a win that he received, bringing equity. He was dealing with a company who was coming after him for some amount, for some balance owed that they had claimed. And he brought acceptance and inquiry to the matter, and the company credited, as you see, Melanie says, we credited all the charges in your account. You're not required to pay any balance, and we'll remove your account from our collection list and close it. That was one that David shared in our group, and just another great win. Here's one from our very own Amy. And she's also partnered with David over there at the Freedom Studio as well. This is just for a traffic matter, but it's in Australia. This was in connection with there was like a 2,000 Australian dollar fine that they had levied against her, and some whole traffic matter. There are actually multiple traffic and parking cases that were dismissed for her, as well as the fine. She never had to pay it. It was sent to Fines Victoria, but it was never sent along for further collection. It was paid with acceptance. And here's just a letter showing another speeding offense that was dropped once she brought equity. And it says, following a review of the above mentioned matter, I wish to advise you that no further police action will be taken against you. Wonderful. And that's from Constable Cashmore, which he got some more cash from Amy's acceptance. He must have appreciated it. Here is a testimony from a mother in bringing equity. She had been helping her son to bring equity to five credit cards, unsecured debts. Um, they both went through the equity course, and there was a bench trial that was scheduled on one of the five cases, was totally dismissed, and the other four cases were dropped shortly thereafter. And here's actually the cover letter of the court document showing that the case was dismissed. And it says, comes now, plaintiff, and hereby dismisses the above titled cause of action without prejudice, with cause to be taxed to plaintiff. So and on the left here, she showed a picture of all the mailings that she sent. It looks like a lot more than it actually is. Those are actually envelopes underneath each of those pieces of paper. So the envelopes are kind of stuffed. So it's not like thousands and thousands of pages like your eye might deceive you when you first look at it. It looks like it's about 30 envelopes or so at the most. Yeah, it's probably her largest mailing. It was quite an impressive stack of paper there. And those pieces of paper in between the envelopes are certificates of mailing, which we use instead of registered mail. By the way, for any of you that are used to paying all sorts of money for registered mail and certified mail and all this stuff, we don't do any of that in equity. We get by just fine with a far less expensive version. So if the class is a little bit out of your price range, just know that you're going to be saving thousands of dollars on postage anyway. So it does kind of equal out. All right, here's a few more testimonies. Again, another one from our very own David, and then Hillary and Bella. Hillary's talking about a credit card discharge and some spiritual aspects which she learned throughout the process. It was nearly a $6,000 balance, and quite a nice testimony. She was one of our very first students, so it's great to see her still getting wins to this day. Uh, David compelled performance with a service provider in the hospitality industry. They were coming after him for $1,000 fine. And he also had an active account, but he seems like he managed to maintain his account and discharge the fine, which is quite nice. And Bella is discussing a matter that her and her husband brought equity to, a Discover credit card. And she said that eventually the lawyers filed a non-suit, and they received a notice that the case was dismissed. Quite a bit like the last slide we showed you. So she didn't even have to appear in court in that one. It was quite an easier win. Here is from a student. We'll call him K. Um, oh, it shows his name Kenneth. Okay. Well, Kenneth discharged a almost $22,000 hospital bill, and he provided some proof of that. You see the itemized here. The man was in a car wreck, God forbid, and he's all healed up now, but he was carrying a $22,000 bill from it. And after just a bit of back and forth, I think it took about 4 or 5 months. And again, not that was constant work during that time. It was really just a couple of notices a month. Now you're seeing on the very right the highlighted portion where it says a $0 balance, and they did an administrative adjustment from $22,000 down to zero and applied the acceptances. Here's a very interesting case that I worked on with a woman named LaJohn. She is a teacher in California, and they were coming after her for some trumped up claims because she'd gotten a side job as being able to pick up some hours at the school that would be more lucrative, kind of after school care. And some of the other teachers were upset about it, and it was kind of a shady place. And so they were able to trump up some administrative charges against her and try to railroad her and get her fired and all this stuff. And they had a whole tribunal. California is crazy with its like over interlocking tribunals and review boards and attorneys and all this stuff. And so we were just able to cut right through to the heart of the matter and get her a wonderful document it took us quite a while to write it, but kind of highlighting a lot of what had been done and how she was consistently in the right. There was a long record of her being a fantastic teacher and certainly walking the line according to their rules and things. What's that? Yeah, so we employed the art of inquiry in this matter, and here you can see she received a uh, a letter from the license enforcement. They were trying to take her teaching license, and she got a letter from the Division of Licensure Enforcement telling her that the Office of the Attorney General has declined prosecution in your case. Accordingly, please be advised that the matter has been closed. So we helped her to clear her name and be left the heck alone so she can return to teaching unhindered by this attack. Quite a unique case, a very interesting application of what we teach. All right, here is a testimony from a young man named Tad. In December of 2024, I was facing 52 contempt charges related to my nightmare of a family court situation. The truth movement was and still is a scattered array of gurus, well-meaning truth seekers, and the desperate to find remedy. I was among the latter. What we call patriot methods, arguing jurisdiction, arguing the law, challenging the courts and judges, was the norm. Yet no remedy could be found. Rather, it seemed to complicate and escalate the issues people were already facing. Then there's the equity buzzword. It was heralded as the answer to everyone's problems. Gurus would throw that equity word out, and it seemed like a magic wand that drew people in. Yet there was no clear definition of what it was, why it was the answer, or how we utilized and applied it to our various circumstances. Equity became the remedy we were all chasing, yet it was fleeting, undefined, and led to even more rabbit trails with dead ends. I had joined a dedicated group to study this equity idea, unpacking pre-1933 books like Gibson's Suits and Chancery, uh, Levine's, and sticking to the 20 maxims like my life depended on decrypting them, and wholeheartedly studying the works of Rourke's Kingdom versus Empire as though this was the playbook to defeat Babylon. Yet again, I came to a place of complete discouragement, as nothing I studied could be applied to real-life court, and real-life court was what I was experiencing. My over 40 court appearances proved this. And it was family court, where my rights and time with my son were threatened and being put at risk, and where jail time, contempt, and that's criminal contempt, and absolute corruption whittles a man's spirits down. After my many court failures and now facing 52 contempt charges, is when I found Julian, or better said, is when Christ our Redeemer in his goodness planned our connection. Julian and Maggie were incredible support, teaching me real and practical equity and taking the time to train me to prepare for court. Julian and I had practiced my court script. He played the bad judge, asking the hard questions, and I rehearsed my answers over and over again. I appeared before that truly grumpy judge for 2 hearings and had all 52 contempt charges dismissed. If you're here taking classes, you're in the right place. Amen. And a beautiful testimony from that young man. Um, yeah, 52, and that's criminal contempt. That's a lot more serious than civil contempt. That's criminal contempt of a court order, punishable by quite a few months in jail, and 52 charges dismissed with equity. Here is on the left, we have dismissal of a property tax case. Again, I wanted to take these screenshots directly from Telegram. Telegram has a system where it has the person's name as forwarded from, you know, if you are taking the message and forwarding it somewhere to save it, it'll keep their name on there. Some people wanted to have their names removed, and we've removed their names to protect their privacy. Um, but yeah, just that kind of lends the air of proof, because there's no way to fake that on Telegram. So this was forwarded from an actual chat that we were in with for an equity teaching, and this person is talking about 2 years of standing on his square, as he puts it, in equity. Of course, we call it standing on the rock, and he received a paid receipt from the county assessor regarding his personal property taxes. He also says, "He who leaves the battlefield first loses," and that is very true. You have to stick with it. You can't give up. He goes on to describe that he never even did the most powerful aspects of the process, some of the more advanced tools that we teach in the class. That's probably why it took 2 years. But even just using the more basic tools, he was able to get property taxes dismissed. And indeed, we have never lost a house to property taxes. Property taxes are something that require a more intense usage of our tools, but we have very consistently discharged property taxes, never lost a house to them. Here's on the right, we have a testimony about a win with the New York State Department of Taxation. And there was a judgment against this individual for a civil matter involving taxes. And they state there was a balance of $1,000, which they don't recall seeing anywhere. Um, I believe there was actually a higher balance in this matter, but as what happened with the IRS in one of the previous letters we showed, the acceptances are applied behind the scenes and kind of whittled down. Um, but the letter did state, therefore, satisfaction of said warrant is hereby acknowledged, and the clerk is hereby authorized and directed to satisfy and discharge the same. And they actually use the term discharge. Very, very interesting. Of course, we are taking advantage of their accounting procedures, and they do recognize the terms that we use. Here's a testimony. The name was not included, but this is from somebody we'll call W. And he had another experience of going to court for unsecured debts. Him and his wife were both on the account, so they both had to appear. And he was being sued by Zwicker and Associates. That was the debt collecting attorney. And this guy was very doubtful. He's very doubtful that equity would actually work for him. But when he got to court, the attorney stated that they would be non-suiting both of their cases. And as he says, the wife and I have said, "Holy cow, it worked," more than 50 times since we left the court. This is an equity success story that he couldn't fathom happening, and now he's trying to fathom that it really did happen. So we are very pleased to see that. Here is a testimony from one of our students, Rose, who compelled performance with the Tennessee Department of Revenue. Tennessee, we lived there for about 4 years. It's certainly one of the more corrupt states in the country. And they have a long history of that with Governor Blanton and some other pretty infamous occurrings. But even Tennessee is not as corrupt as people say, because they follow their own laws, and when you bring equity, then they are able to give you the remedy that you're seeking. Here's the letter she received saying, "This letter serves as notification that the Tennessee Department of Revenue has closed your sales and use tax account as of May 31st, 2025." Um, and just a wonderful victory for Rose, saved her business quite a lot of money. All right, here's one from A. proof of equity success from a criminal ticket she got from a police officer who said that if she didn't go to court, that she would be arrested. And it says, as of the above referenced date, the NYPD has failed to file a legally acceptable accusatory instrument with this court. There's no need for you to return to court on the summons number referenced above. And yeah, so she had received a summons, but they failed to file an information or a complaint or whatever it was that the court was looking for, and that was because she brought equity to it. So she was pretty happy with that one. Here's one from Joe. He said, "Poof, and just like that, equity delights to do justice and not by halves, and equity aids the vigilant, not those who slumber on their rights. I was issued 10 citations a couple of months back in my wife's car. After dealing with my court case, which was for 9 other citations in my personal car, which were dismissed, I continued to accept any presentments put before me, and after my last round of mailings, I was able to compel the court to discharge the 10 citations. These are all the pictures I screenshotted from their website for each citation. The ticket number itself doesn't show, but the case number does. I trust this will give someone some encouragement." And so these are actual case numbers, and hopefully, yeah, they seem to be too blurry to look up, which is good because we don't want to we want to respect Joe's privacy. But and they all do say case expired. You can see that at least because it's bolded. And no, this is 1, 2, 3, 7, 10 citations that would rise to the criminal level. I mean, he was dealing with some repeated offenses, and so it was rising to the criminal level at this point. And even still, we were able to get it discharged for him. We've discharged many criminal matters. Here is one from Luke, a student of ours. Um, he brought equity post-judgment from a credit card case. And this was, he had already gone all the way through court and got a judgment against him, and did not find equity until after he had already got the judgment against him. And even still, equity was able to go back and clean up the mess and, yeah, completely discharge the judgment. So it's like I said, equity can go back and time travel, or effectively do what ought to have been done. You can go back and clean up the record. And so there's many such examples of this. This is just one. And you can see Luke is quite happy with it. He said, "The case has since completely disappeared from Pacer and any other court case finder website." Well, this would be at the state level, so Pacer doesn't apply. But he was very diligent. He just wanted to make sure. Credit cards are always at the state level. Completely disappeared, and any other court case finder website. I can't find anything on it. I believe another student in here had success with the same combination of plaintiffs and attorneys, American Express and Zwicker and Associates. And that wasn't the one we showed you before. It was actually a third individual. So I left well enough alone and have since moved, voluntarily, of course, not running away from anyone. So that's great. Just shows that, exactly what we said about equity time traveling. Here's one from Brent. He said, "Learning equity, as taught by Julian, is an invaluable investment that yields lifelong dividends. To date, in terms of successfully discharged financial obligations, I've realized a 17-fold return on my initial investment in the well, now it's called the Honor with Equity course. Moreover, I am not special or unique, as many other equity alumni have done likewise." Brent's a great guy. Very, very successful in equity, as so many of our alumni. Here's one from C. He said, "Update on my court case that I've been sharing about. Today we had a court trial conference hearing. The prosecution motioned for dismissal for a made-up reason. Judge immediately dismissed the case." Not sure what that matter was in relation to, but there's a lot in the testimonies folder like that. Here's one from W. She said, "I got those letters and responded with steps 1 and 2. Soon it became a lien on the property, and FTB took my salary directly. However, just continue with the process. I did bring FTB, that is the Franchise Tax Board, California's state tax authority, actually the most aggressive tax agency in the entire world. She said, I did bring FTB into dishonor. That's part of our process. And half a year later, FTB dropped my case and returned most of the money that they took. And any remaining balance, we're all she would need to do is continue to ask them about it. Though she, like Luke, she may have just left well enough alone. Um, but yeah, I mean, so that's equitable redemption at play. And even when the FTB, the most aggressive tax agency in the entire world, if they garnish the wages, if they levy the bank account, or even if they put a lien on the property, they'll release the lien when you bring equity, and they will return the money that was taken from you against your will. Now, if it was stuff that was withheld according to your W-4 or whatever on your paycheck, that's a different story. That's something you're giving up voluntarily. We can teach you a better way, by the way, to compel your employer to stop withholdings. But if you're giving it up voluntarily, equitable redemption doesn't apply. But in this case, they garnished her wages and simply returned all the money to her at the end of the equity process, or most of it, and she has the ability to inquire about the rest. Here's one from Arlene. She said, Good morning. I obtained a release of lien on a vehicle at the beginning of last year through equity. And so that's even for a secured debt like a mortgage or a car loan. Equity can still bring victory in those cases as well. They can be quite a bit more intense. More of your tools need to come out, and we probably need to do some court practice together because you're going to have to stand on the rock before the judge. And we do incorporate a lot of court role play into the class itself, but sometimes you need specialized. But anyway, this is a testimony from Arlene. She used equity to discharge her car loan. Here is a testimony from Anna. She said, just to let the class know, my court case with Chase Bank just rolled into the station, as Julian likes to say. I received a letter yesterday from the lawyer with a court document to vacate and dismiss the case. I will do an acceptance, one step, and that should be the end of it finally. Alleluia. And thank you again, Julian and Maggie. So just more unsecured debts than you can possibly count at this point. I'm sure it's over $1 million in credit card debt at this point, millions of dollars in IRS debt, CRA, ATO, you name it. And then, of course, even secured stuff like property taxes and car loans and even mortgages. We've discharged all of these things. And then leaving the realm of civil and getting into criminal, we've even discharged many criminal cases as well. It seems like every series we get somebody that did a Patriot method and did right to travel and got arrested and got the book thrown at him and he's dealing with all sorts of criminal charges. He has to learn equity on the fly, and we're even able to help people in those cases. Not our favorite case because we certainly like to help people before the problem arises. It can be a little bit more stressful to bring equity halfway through a court case that's already been going in the wrong direction. But equity can help you to repent, which is to turn away from a bad path and embrace the path of honor and forgiveness and peace. And in that, we can see the charges discharged and the individual will be left alone, even in a criminal case. And even at the federal level, we've gotten cases discharged, criminal cases, bankruptcy cases in some matters as well. So there's really nothing that equity cannot be brought to so long as you are the one that they're coming after. If you're a plaintiff, we can't help you. The equity's not for that. But if you're a defendant and somebody's trying to get something from you or trying to force you to do something or trying to put you in a cage or take your money, equity is always available to you. And here's another one from Matt, another IRS win. He said, Good afternoon, Julian. I received an LTR 288C from the IRS today for my 2023 taxes, stating they have determined that no action is necessary on my account. Good news. A big thank you to you and your team. Also, I'm pretty sure I didn't tell you, but David Greenberg was the one who referred me. So thank you, David. And I believe David was helping him as well. So that was a team victory there. And here's one from Z. This is one of the individuals I was talking about who, it seems like every series we get one of these where somebody did right to travel stuff and got, just totally attacked by the police and the court for doing it, and was able to use equity in order to discharge the charges. She says, Victory! At the start of my trial, the judge ordered a competency hearing, was going to move trial to May, but then the prosecutor came in and said he moves the case to be dismissed. So 5 minutes into my trial and my case was dismissed. wonderful testimony from Z. And that is just a smattering of equity testimonies. But there are many, many more. And of course, once you go through the class, you have access to the alumni group where you can see everybody sharing their wins and discussing these testimonies and getting help from us and from each other on applying equity to their situations. So our website is standingontherock.com. You can also message me on Telegram at the Telegram address shown there. But if you go to the website, it's a better option for you because just go to standingontherock.com and you'll see the option to book a free discovery call with a member of our team. Um, and of course, actually, I would suggest that you use the link in the description of this video as as that, and then we'll know that you came from David and the Freedom Studio. So that's actually, we would like you to use that link as opposed to just typing it in. Either way, we're going to ask you where you came from, so we'll know. But that'll make things easier for us. So thank you so much, everybody, for being here. Thank you to David and everyone at the Freedom Studio, and be happy to take questions now.
Thank you, Julian, and great presentation, very compelling.
Awesome.
Also, before we take questions live, I had suggested perhaps catching up on some of the questions from the chat. If you want to do that first before we go to the live questions, or we can mix them up, whatever you guys think is best.
Well, you take the lead, David. Whatever you think.
Let me just quickly call out a few questions that were posted through our social media. So this is people that were um, not in the Zoom with us. So let me just scroll back here and see if we can pull up some of those questions, and I'll just cross-post them here so everybody can see them. So this one was earlier in the chat. One can provide new consideration to do reconciliation on the account, but what mechanism compels the other side to settle the account? So I guess they're just asking, like, what is it that actually causes the discharge to occur?
Well, we dig a deep dive into the primary source material that shows exactly what compels a discharge to occur in the class. Obviously I can't walk you through all the UCC codes here live because that's quite advanced material. But whether you're dealing with the UCC in America or you're dealing with a combination of the Bills of Exchange Act and your country's Personal Property Security Act and other accounting acts of the last 30, 40 years or so, no matter where you are in the Western world, we give a full breakdown of the acts of Congress or the acts of Parliament that led to the situation where our acceptance compels discharge. So it's not something that I can get into right here. It is quite advanced material, and it's something we cover towards the end of our class.
Exactly, and it's also private, the difference between public and private remedy. Here's another question. How can a plaintiff bring equity, or is equity only for defending? Also from social media.
Yeah, I mean, there's a lot of people trying to use equity as a plaintiff, and of course, before 1933, before equity was merged procedurally with the overall commercial court system, that was possible to bring a plaintiff action solely in equity. But when you bring a plaintiff action, you're asking the court a favor. You're asking for benefits from the court. You're volunteering for the court to take jurisdiction, and there's simply no separate equity court to do that in anymore. So there's three states in America, at least, that still have chancery courts, but it's a very commercialized form of chancery. Um, if you're going to be asking the court for benefits, you got to play by their rules. You're basically volunteering to be under their statute. So if you can't settle and I understand there's good reasons to come out of equity and be a plaintiff. If somebody's wronged you and you're seeking a remedy, there's nothing wrong with that. It's just not something that I have ever seen done successfully in equity because of the procedural merger. When you volunteer for asking the court for a benefit, they require you to play by their rules. And in the modern day, that means Admiralty Maritime statutory, not pure equity, which is really no longer available procedurally. Now, as a defendant, if you're not volunteering for their benefits, equity is fully available to you. But as a plaintiff, I have not seen it applied in such a way that it could work.
Excellent. Okay, going back to some earlier questions in the chat, Mike is asking, what is the legal basis for your program? Please identify the specific statutes, regulations, constitutional provisions, or case law you rely upon.
Yeah, so I mean, equity is, I mean, if you're from America, obviously, so you're asking about the Constitution, so I'll just address it on American terms. Equity is Article 3, Section 2, Clause 1 of the Constitution. It mentions law and equity as powers that are available in judicial matters. Equity has 700 years of precedence in English jurisprudence. So that's really just one wing of it. The other wing of it is exploiting the, modern financial system and the modern monetary theory that we're under. If you look up a little booklet called Modern Money Mechanics, released by the Chicago Federal Reserve, you'll find some of the basis for what we're teaching. Obviously, like the first question, I mean, I go deep into the primary source materials of how and why they have to take our acceptances, and they really don't have a choice about it, and they're bound by their own laws to do so. This is not something I'm going to get into in a public forum, but equity is just quite blatantly, part of any common law jurisdiction, and I did show some UCC codes and some definitions which form some of the basis. Basically we use um, concepts of modern finance and modern money mechanics, and we wrap it in a container of equity in order to compel performance. And that's kind of the gist of it. And if you want to search it out more, you can check out our website. I can't get into, hardcore specifics for you and cite all the individual codes. In that section of the class, when I get into it, there's about a dozen or so UCC codes that I walk you through, and the UCC is written in a very um, obscure way. So we have to take our time and walk through each code and each subsection, and that kind of lays it all out. And then of course we do if you're outside the United States, we walk you through the Bills of Exchange Acts and the Personal Property Security Acts and any other relevant financial legislation that forms the basis for what we teach.
Great. Mark had asked about Europe and Roman civil law countries. I know this is something that you've addressed before, Julian, but if you want to touch on that.
Yeah, so depending on how closely that country has matched the Western financial paradigm, equity can be brought even in a civil law country. The closest match is Germany. Germany has a very robust, the closest match for a civil law country. Germany has a very robust um, security interest framework that closely matches English jurisprudence. Germany doesn't have equity jurisdiction per se, but it has equivalents of equity jurisdiction written into their laws. So there would be some adaptation needed, but I would love to get some German students. I would, especially after everything that happened there a few years ago. Like I would really love to help you guys, deal honorably with your government so they can just finally leave you alone. And equity would be very applicable in Germany. For other countries, it just depends. France has a very robust financial framework that is similar to English jurisprudence. Equity would work very well in France. Um, it really depends. And we have an interactive map coming on the website, standingontherock.com, that will, you can hover over your country and see if it'll be applicable with a little bit of application, or maybe it'd be applicable, but there would be significant adaptation needed, or maybe, it's somewhere like China where, it's just not going to be applicable at all. Um, so we have that coming soon.
Excellent. That's good news and encouraging that we are looking to help people in other parts of the world, not just in the US. So I'm going to just paraphrase another question from Mike just to kind of condense it down. He's basically just trying to understand your use of the term equity, whether it's referring specifically to the historical body or if there's some other usage of that term.
Oh, there's many uses of the term equity these days. It can mean value in a house. It could mean, whatever the liberal government's doing. But the equity that we're referring to is specifically equity jurisprudence, as descended from English law, which is readily available in all common law jurisdictions, and its equivalent is available in many civil law jurisdictions. And there's about 20 or 30, there's closer to 30 maxims of equity, which are just kind of hard coded into the justice system. They do evolve over the centuries. The maxims are not set in stone, but they're pretty set in stone for any given 100-year period, and those are quite important to everything that we're doing as well.
Great, great. Okay, Paul was asking in a different tone, a different lane. He's asking what role could equity play in privacy with the current digital surveillance mechanism? So kind of speaking to the encroachment of surveillance, excuse me, surveillance everywhere and how equity could help in that.
Yeah, so I mean, we also teach a class called the Equity Trust System, and this is incredibly useful for privacy matters. Uh, the equity trust system can get your name off of things and keep everything at an arm's length distance. That's actually a legal term, an arm's length from you, so that your finances and your operation within the commercial world, which is becoming increasingly surveilled and tracked, all of those dealings that you have commercially are now separate from you. So it's the trust system is going to help immensely with that. And then the equity course teaches you how to discharge any attempts to compel you to do things against your will. So if you're being required to, register for something, or turn over biometric information, or what have you, equity can stop them from can discharge whatever they're trying to bring against you. Now, if you're looking for benefits like flying on planes to other countries and stuff, then things get a lot more complicated. But when it comes to purely them just coming after you for something for no real benefit, then equity will always discharge that very cleanly. And then the equity trust system will help you to have a business, to protect your family, and that separate class will teach you everything you need to know about privacy and how to get your name off of things, and operate in the modern commercial world without giving up all your information and being tracked all over the place.
Very clear. Okay, here's another question from social media from someone who's watching live on YouTube. This is from Tobias Brown. Was there a specific method used for the credit card balance that was brought to zero while remaining open? Or was that outcome based on the discretion of the card company?
I think they're referring to your testimony there, David.
It could be. Yeah, it could be. It might be worth just re-emphasizing that the issue that usually when we are accepting a benefit through a contract and we do a discharge, we're going to lose the benefit. Now, it's not 100% apparently, but we need to presume, it seems like, Julian, maybe you could speak to that part. Should we presume, or is it typical that we would lose the benefit, or how that works? But you're correct. He might have been referring to the case where I was able to discharge an issue, but still continue to use the account. But it was not a credit card account, just to clarify. Yeah.
Right. So when we pay with banknotes, I mean the matter just keeps going on. The account stays open, and really the banknote. I mean, if you look up the definition of note, it's just a promise to pay or an evidence of a debt. So all it's doing is kicking the can down the road for the next generation and increasing the national debt. When you pay with equity, you're bringing actual discharge, which closes out the entire line on the ledger, not just the public side. And so you're actually decreasing the national debt. They will close the account because there's nothing there to justify it anymore. The whole thing has been discharged. There's even a maxim of equity which backs this up. It says equity delights to do justice and not by halves. In other words, equity won't take any half measures. It'll just totally nuke the whole line item on the ledger. Discharge both the public and the private side of the ledger. And for that reason, they do typically close out the account. But we have seen some rare cases where they kept the account ongoing. This is one reason why we don't really suggest bringing equity to like utility bills or things like that. Um, it's really the much bigger bills like the tax bills and stuff that we bring equity to, the credit cards, the mortgages, and things like that. So yeah, you should certainly assume, like David said, that the account will be closed because 99% of the time it is. Doesn't mean you can't open a new account with another bank. You know, it's not like they put you on a blacklist. But equity will close out the account and discharge both sides of the ledger.
Got it. Okay. Mike had a few more questions. I'm just going to briefly summarize them. One was he's asking if there were appellate court decisions where discharge occurred, where this was successful.
An appeal is you're contracting with the court for a benefit. So we actually would rescission the entire appeal. That's how we would go about that. We absolutely cannot seek remedy from appellate courts. We don't need to. We get our remedy from the main court. We don't need to go to the appeal level. So if you appeal, you're the one initiating the action. You're asking for the benefit. You're asking the court to get involved in your life. They're taking full jurisdiction over everything that you're doing. You're no longer there for one special narrow purpose of settling the accounting. Now you've opened up the full scope of statute to be wielded over you. So we cannot work at the appellate level, and we don't need to.
Very clear. Very clear. Equity will not aid a volunteer. So we are doing whatever we can to not volunteer to have the courts adjudicate. I would still say, even though we're not afraid to go to court, the objective is still to keep things out of court, in my opinion. So anything
Yeah.
we can do to resolve matters privately is going to be advantageous.
Yeah, I mean, we can prepare you for the hassle, but why invite the hassle in the first place?
Excellent. Mike's next question is a great question. I think everybody can benefit from hearing the answer. He's asking to clarify the power of inquiry. He's referring to it as somewhat mystical, so maybe not really understanding what actually gives that force to discharge matters in these legal realms. So maybe you can speak a little bit to the power of inquiry.
Sure. So, our remedy comes from the acceptance process that we use and the fact that we're not contracting with the court for anything broader than that narrow accounting application. So there's a million ways that they try to contract with you, and we keep it to just that narrow application of settling the accounting matter like a commercial matter because all of these things are commercial under the modern monetary system. The inquiry is really just a way that we keep things focused on that narrow range of remedy. So the court will try to open up all sorts of other avenues with you and ask you all sorts of questions, try to get you an attorney, try to get you to use their filing systems, try to get you to start arguing and creating controversy. And the art of inquiry is how we shut those attacks down. So really, the acceptance is the remedy, and the inquiry is kind of the uh, the defender of that remedy, is one way you could put it. The acceptances, though, very often will settle a matter before it even gets to the point where you have to bring acceptance. The inquiries will settle the matter, and the way that we do that is, our questions, our inquiries bring to light the things that they're doing in the dark, and for that reason, it pricks the conscience of the person that you are inquiring. For anyone who has their conscience seared, we can also just go the route of implying forward-looking tort liability with our questions. And often you find that really pointed questions kind of resolve a matter before it ever even gets escalated. So the art of inquiry is can seem a bit mystical, but we do impart that in the class. We show a number of examples, and of course we're always checking over the students' inquiries in an ongoing way in the alumni group. It is an art form, and it's one that can be absorbed over time. The more that watch our materials and the more time you spend with us and kind of ask us to review your inquiries in the alumni group, which is free of charge for our students. Um, and it's really about just coming in peace, pricking the conscience. Maybe you imply some tort liability if the person is not responding to the pricking of the conscience, and you're just bringing to light the secrets that they keep in the modern financial system. And when you do that in a pointed way, and you're not treating it like an English lit project where you're just throwing everything in there. You ask very pointed questions, and they are incredibly effective. Our inquiry notices actually do a lot of the heavy lifting in these cases.
I'll also add to that, a great way for folks to test this out in their own life is just to see how powerful it is just forget about courts and public matters. Just something comes up in your life where there's a disagreement, maybe with a spouse or a family member or a colleague. Instead of arguing about it, which is what most people do, see if you can ask one or two really direct and pointed questions to try to get to the heart of the matter. And see what happens when you do that. Of course, it's unpredictable. There's no way to know how the other party is going to respond, but I would encourage you to do this thought exercise, and you may be surprised by what happens.
Yeah. Yeah, it's super powerful, David.
Awesome. So that's a great way for people to really put that into practice. Let's see. Mike had, I think we already answered his other question. He was asking for like um, publicly available court records, but I know in the case studies you shared earlier, you had cited a few courts. It might also be worth clarifying, though, that the court, what you meant by the court's not going to hand you the win, even though there is a discharge, because I think Mike and others might still be looking for, case dismissed on equity or something like that. And maybe you could speak to how the court indirectly acknowledges equity, but they're not going to ever hand you the win directly, or at least most of the time.
Yeah, I mean, there's almost no cases you can look up and just where it says, "Oh, congratulations, you brought equity, you won." Um, I've actually, if you read some old Patriot materials, like from the 1990s and stuff, sometimes they'll cite actual court cases, especially at the federal district court level. And when you go to look up those court cases, nothing comes up. It's not even that the case has been sealed. It's just that it's disappeared. But then you can actually go deeper into the individual district court system and see a list of all the case numbers of all the cases that they heard that year, and you'll find that case number in there. But then you type it into their search system on Pacer, and it's gone. So this isn't just equity. I mean, no Patriot process is typically able to show you those public wins because they don't leave them up there for you to be just touting them around to people. I mean, how easy would it be for us to get people to enroll in the course if we could just if the judge was just like, "Oh, you congratulations, here's a trophy and let us just leave this up here on the public docket for everyone to see." Um, the only ones you're really going to find are cases where like the student gave up halfway through, or they just made some like critical error that we told them not to do, and they did it anyway, and the case went in a bad direction, or they just gave up and started mixing processes and thought they'd get back into arguing and fighting. You can find a few of those, and those cases are tragic, but certainly not based on our teachings. But you're not going to find the ones where the students got victory. There's so many of them, and every single time it's like they either get sealed or just disappeared entirely. The individual will get a letter very often saying, it's done, it's settled. But to just leave it up at the public level would be very foolish for an establishment that's built upon secrecy and protecting the modern financial secrets that keep it in operation.
For sure. Mike was also asking to clarify the scope of where equity can be applied. So just kind of citing a few examples. So my understanding, and Julian, feel free to fill in anything I may have missed. Really, it applies to any public obligation where we want to fully settle the account. So that goes everything from parking tickets, speeding citations, all types of tax obligations, unsecured and secured debts, civil charges, so judgments and charges in the court, but also criminal charges. Do you feel like
Yes.
I left anything out, or is there anything else that you feel falls into that bucket?
Well, there's a couple other random things like, the county coming after you saying, "Oh, we don't like how close your driveway is to this creek," or, you need to paint your trash cans red so we can see them better, or, any of these like weird county codes they come after people for. We've had a lot of people discharge that kind of stuff. Random fees and fines. And we even showed the testimony of the woman. She was very much in a statutory framework. She's a teacher in California, but they were coming after a license, and there was a specific application of our tools and the things we teach in the class that was even able to reach into that, highly voluntary benefit driven system in a certain way to provide remedy in that case. So it's quite a broad application. Um, just because somebody's applying for a benefit doesn't necessarily mean equity is not available to them. It just becomes a little bit more complicated. But generally speaking, the list that David mentioned is that's our bread and butter, all that stuff. And then there's also some like rare and random applications where equity is very powerful indeed. So anytime somebody's coming after you for something, wants something from you, wants you to pay, wants to charge you, equity's got your back.
Great. Mike, apparently a different Mike, is asking about the notice of liability, just kind of comparing. So he's referring to the notice of liability, which is similar to conditional acceptance, I believe, which is basically um, putting commercially putting liability on the other party. This is used, for example, people who are dealing with the jab or 5G meters, in power movement, so Cal Washington's movement. So I think Mike is just asking for you for your perspective, like comparing what they're doing for commercial remedy versus equity and how equity may even apply for dealing with things like smart meters and 5G and so forth.
Yeah, so it's kind of like having just the inquiry without the teeth of acceptance to back it up, which is fine in a lot of cases. I mean, you can compel performance just from implying the like as I said, our inquiries can sometimes imply forward-looking tort liability. Well, that's exactly what a notice of liability does. It's implying forward-looking tort liability, saying you could be liable, if the judge, if I take you to court and the judge agrees with me on all this stuff, you could be liable is what it's really saying. Which is often enough to compel people to drop a matter because they say, oh, this guy's too much trouble. Oh well, he's right. Like we may harm him with this. Like we probably should, back off with our smart meter or whatever. So it occurs dismissal of matters, I guess you could call it. Stops matters from being escalated to the court level. And I'm sure they see some success with that. Um, so, our inquiries do kind of the same thing in a certain regard. They imply forward-looking tort liability, but then if they do escalate it, which like 80% of the time they're probably going to do, then we have acceptance to actually fully discharge the matter. We're not just making threats and implying liabilities. We're actually, backing them up and holding them to their own laws to fully discharge the matter, no matter how far they escalate it. So that's kind of the difference. It's mostly equivalent to our inquiry form, although. Um, Inquiry has to be quite a bit more artful because it involves this aspect of not creating controversy, not contracting in a general way. Whereas notice of liability is just full of controversial statements and things that would ultimately have to be settled by a court, whereas an inquiry is just more speaking to the conscience of the matter.
Just to ask a quick follow-up here, which I think is also in the language of his question. D- And Julian, from any of the testimonies you've seen, whether shared today or otherwise, do any of them fall into that bracket of perhaps stopping other party from imposing some of these things like 5G smart meters? Again, just kind of using that category. Have you seen anything within that realm in terms of what was already accomplished?
Yeah, so, several of our students have used the inquiries in regards to smart meters. There's been some success there. Um, it's it's a tough one because you're asking for a benefit from this company, and some of them offer an opt out, so you can just take that, but then others don't. So what do you do? I mean, my idea of a solution, um, for a matter like that, if you believe that this thing is harming you, which it does put off, some kind of some dirty electricity in some regards can be harmful, and some EMF radiation, which can be harmful. Um, I would suggest just a literal physical solution, like just putting up some Faraday material behind the thing, or enclosing it in a box that can be opened. You know, you're not trying like you don't want to give them the ability to argue that you're trying to defeat their ability to bill you. Um, but if you just enclose it in some Faraday material or put some Faraday material in the wall behind it, I mean, people, kind of go way overboard trying to get a legal solution in a voluntary issue sometimes when they could just have a very simple solution, um, with a little bit of DIY work. So, yeah, I mean, you're asking for a benefit. Equity will not aid a volunteer. Sometimes it does anyway, because we can imply the forward-looking tort liability before it escalates, and they just drop the matter. But when you're asking for the benefit of electricity or whatever, it's sad that modern society is set up that way, but it is technically a benefit. So I suggest just a more practical solution personally. I mean, it's gonna work 100% of the time as opposed to trying to litigate and imply liability and stuff, which is, only good if it scares them into not escalating. Um, and the equity that we use would pretty much be limited to that, as opposed to, being able to discharge something because you're asking for a benefit.
Excellent. And I would just add to that, people get bent out of shape about these advanced things, but what about turning off your Wi-Fi when you sleep? What about
Yeah.
turning your phone off and putting it into a Faraday bag, like the one sold by Mission Darkness, relatively economically, and others, or creating your own if you're crafty in that way. So it's kind of like people are jumping to the biggest thing, but they're not even addressing the small things that are eroding their health.
Yeah.
Just one
Yeah.
way to think about it.
Or just get yourself a can of lead paint, and paint your wall with the lead paint and then paint over it with some normal paint so it's not flaking off in your environment. I mean, it's pretty easy.
So hopefully people will address the smaller things first, but it's still a very valid question, obviously. Let's go to some questions from Heather. Heather is asking about applying equity to life insurance policy payments and CRAs. I'm not sure if she said CRA is plural. I'm not sure if she's talking about the CRA or something else. Um,
Well, when it
and
comes
she
to
said,
life and oh, sorry, go
go
ahead.
ahead.
Okay.
And she said the last part of it is, sorry, don't need to stack. We'll come back to the last part of it after you answer that part. But she's asking about life insurance policies, and then she mentioned something about CRAs, plural.
Sure. And CRAs plural may be referring to Canadian retirement accounts. Um,
I think she meant credit reporting agencies. Now I figured it out.
okay.
Sorry about that. Yeah,
All
fine.
right. So for the life insurance policy, again, you're asking for a benefit. You're contracting with this company for a benefit. So they're just going to close your policy if you bring equity to it. Now, if it's a situation where you've gotten yourself into a contract that is burdening you and you no longer want the policy, but they're still trying to come after you for an amount, of course, you can bring equity to that, because you're no longer seeking a benefit. And we've discharged cases like that several times. And then for credit reporting agencies, again, you're seeking a benefit. However, the inquiry notices, in much the same way, with raising the forward-looking tort liability, pricking the conscience, we can use the inquiry notices. We also make some recommendations for methods to clear out the credit report. They aren't equity, but we have people working with us that have quite a lot of experience in the credit repair world, and they have some excellent suggestions for you.
Excellent. Excellent. Yeah, and insurance go well with trust systems too, to what you were talking about earlier. So,
Oh yeah.
insurance policies will probably play a key role in different aspects of operating privately in trust. And Justin just sharing some feedback, no question yet. He's just saying super presentation to both of us and everybody present. So thank you, Justin.
Thank you, Justin.
Okay, scrolling down here. If one is, this is from Matt, if one is retired military and receiving retirement pay, can this process be used to stop deductions? I'm assuming he means tax deductions.
So there
Go ahead.
are a number of different retirement vehicles that we have successfully stopped withholdings on. Nobody's brought to me a veterans pay matter to bring equity to yet, but I'm sure it will be highly applicable. When it comes to 401ks, IRAs, those kinds of things, and the Canadian versions as well, the RRSPs and the RRIFs. Um, we have experience with those, and we have in Canada it's quite a bit harder. You have to really jump through some certain hoops, and actually the trust class becomes necessary in some regards if it's a RRSP or RRIF. In America, the 401k we have some great recommendations, quite a bit easier. So I'm sure we could compel with the veterans benefits as well. I just have to get my eyes on it.
Great. Julian, how are you? How are you with time? Are you good to keep going? Because we've got a bunch of questions queuing up here.
Yeah, we can keep going.
Okay. You let me know if we need to have a stop at some point.
Sure.
Okay. Angela asked a very simple logistical question. What's the length of the program?
The equity course runs for 13 weeks, and the trust course runs for 11 weeks with a bonus class about a month later. So, pretty similar length of time. And that's meeting once a week. And of course, you have access to the recordings. All our training is recorded, so you can catch up with those at any time. And then you also have ongoing access. So once you're in for life, and all future iterations of that class that we hold, and we do about 3 a year, you can freely join all of those and just sit in on all future iterations. So a lot of the alumni find that very valuable. But yeah, it runs for about 3.5 months.
Excellent. Okay, Tiffany is asking, in reference to bankruptcy that was probably mentioned earlier, if someone is in an active 13 bankruptcy, I guess chapter 13 maybe, uh, or I'm not sure if she means 13 years or chapter 13 there, on a 5-year repayment plan, is there a way for equity to assist in speeding up the repayment terms or to settle debts and therefore decrease the monthly payment? So, in other words, the bigger question is if someone's dealing with bankruptcy, is deep into it, how can equity help in this regard?
Yeah, equity can completely close out the bankruptcy and discharge the whole thing. Um, you can unmake this benefit that you applied for, and with bankruptcy court, there's going to be quite a bit to unwind. I've seen their dockets go into the hundreds. It just depends on the case. But yeah, we can completely close out the bankruptcy, discharge it, and get you to be left alone. Any assets that are already in receivership uh, be very difficult, if not impossible, to claw back at that point. But if you're needing asset protection on the fly, we can teach you how to do that in a way that is fully legal and will help protect your family. It just depends on the situation. But our trust class, the separate equity trust system class that we teach, really teaches best practices even in worst case scenarios, and that's kind of our motto for the class. It's like even if they're starting to take the stuff, you're starting to go into receivership, the IRS is breathing down your neck. We can teach you how to protect yourself as best as you possibly can, even in the worst scenario, and in a way that you're fully protected, and that nothing can be called a fraudulent conveyance or an improper transaction or evasion or any of that stuff. We will teach you to how to protect you from all of that and protect your assets at the same time.
Excellent. Mark is asking, does the inquiry work as a counterclaim? I would just answer, my answer would be no. However, it does put the liability back on the other party. It's kind of like putting the ball back in their court. So it's not a counterclaim, but it is putting the focus back on their side to essentially address their original claim, in equity or, in other words, speak to their conscience. So that's how I would answer it. It's not truly a counterclaim, but it has perhaps a similar effect depending on how you look at it. Julian, what do you think?
Yeah, certainly. And when it comes to the inquiry, that's correct. There are aspects of the acceptance that are a counterclaim, but it's not the counterclaim that he might be thinking of. There's more than one type of counterclaim. So most people think of a counterclaim as just they're putting claims against you and you argue some claim against them and countersue or whatever. But there's also an accounting term of a counterclaim, which is really just where it's like an offsetting of balances. So that would be applicable to the acceptance portion of what we do, but excuse me, but not the inquiry.
Very clear. Angela asks if one can take both of the courses offered concurrently.
Yes, absolutely. And if you go to the website, there's plenty of information about that.
Yeah, I would just add that, from the perspective of a student, as I have taken both courses, it's a heavy workload, especially if you have a lot going on and you really want to get value. Again, you have lifetime access, so it's not like you're gonna it's not like it's a race against the clock. But I would definitely only take on both courses if you have the capacity to conduct study in that manner.
Mhm. Yeah, that's good advice.
Mike asking, what about mead versus mead in Canada? He's asking if you're familiar with this case or if it's relevant at all to our discussion.
I'm not familiar with that particular case. One of the great things about equity is we don't really have to memorize all sorts of case precedents and things. We do cover a lot of that in the trust class because it's very relevant for understanding the powers and responsibilities of a trustee to examine case law. But the great thing about equity is it's above all their statutes and rules and regulations and codes and slip laws and precedents and decisions. So we're really able to just exploit certain financial aspects without having to resort to case law. Um, but there are certainly interesting implications of some of these things, and occasionally we'll review them for the students.
Excellent. Mark here, Mark Victor says he has a hard stop at the top of the hour. What's the next step? So I just reposted the link to the equity page from our website. And there's two options there, just so you know. If you're ready to enroll, you can just go ahead and enroll. It'll pass you through to the enrollment process with Standing on the Rock. If you're not sure yet, you do have the option of also having a free discovery call with Amy, with myself, and we will soon be having a third advisor taking those calls. So you can jump on the call. It's complimentary. There's no charge, and there's no pressure. It's just a way for you to meet privately with one of us to figure out if it's a good fit and if it's going to make sense for you to enroll based on your specific circumstances. Everybody's a little different. For some people, it's going to be more compelling to study this material immediately. For others, it's going to be more of a preventative approach, like, hey, I want to have some tools that I'm not dealing with something immediately, but I want to arm myself with tools for long-term privacy and long-term protection. So that's really what it boils down to. But feel free to either take us up on the free call, or if you're ready to just jump in and enroll, you have that option as well. And that is the end of the questions in the chat. Julian, how are you for time if people still want to raise their hand and do any live questions?
Yeah, we can take a few.
Okay, so the way this will work is if you want to ask a question, let me just make sure you guys can unmute yourselves. Please raise your Zoom hand. Some of you guys are veteran Zoom users, so you'll know exactly what I'm referring to. Some of you guys are brand new beginners. You have a couple of options. You can either keep your hand raised if Zoom has the feature enabled for you, like it's not enabled for everyone, but it'll recognize that you raised your hand. If not, you can just use the raise your hand feature, or you can just type in the chat, I have a question, and we'll call on you. So if you just want to ask directly on by microphone, just get a chance to interact here. Go ahead and think if you have any questions and raise your Zoom hand if you do. And I'm just looking in social media while people are thinking if there's any questions that came up.
It's a humble crowd.
Someone in the social media looks like on YouTube asked if I signed up for the class, I'm willing to sit for 13 weeks, but I'm currently dealing with a superior court case with a finance company regarding a vehicle. I have a hearing scheduled in a month. So they're kind of asking, well, it's 13-week course, but I've got an issue that's already within less time frame. How do I address that?
Yeah, so we offer private coaching. I mean, a prerequisite of that is enrollment in the course, but for anybody needing expedited help, we are certainly able to provide them with that. We can help with the paperwork, we can help get you prepared for court, get you trained up to talk to the judge. And we don't give you just a script for that. We actually train you in a comprehensive way to have a conversation with the judge, even if he's going off script. Even if he throws something weird at you, we're going to tell you exactly what he's going to be talking about. We have many, many, many court experiences. So we know basically exactly what's on the judge's agenda, exactly what he's going to be saying. And we teach you how to deal with all of it. We teach you how to go off script with him and still direct the conversation back to your goals without recontracting with him. So absolutely, we can get you trained up in a fast way to be able to deal with something.
Yep, and equity does not aid those who slumber on their rights. So you are correct um, to take action, to take some action immediately, whether that's to enroll or something else, but at least addressing it. We want to address things. Ideally, in my opinion, we want to address things as early as possible. Going back to that quote from earlier, agree with that adversary quickly. We don't want to put these things off. It's important to, part of being self-responsible is we just immediately confront and address things as they arise and don't let them fester or grow into something greater than they need to be.
Yeah, it'll save you a lot of hassle if you do that for sure.
Absolutely. And I think that's a life skill to be applied across the board. Okay. Well, I didn't see anyone raise their hands. Maybe we'll just do one last call here. If not, how long have we been going for? Has it been about 2 hours?
Yep, exactly.
Okay. So for those of you who are interested in the course, if you're here on Zoom, I already pasted the link. I'll go ahead and paste the same link in on social media for those who are watching online, but maybe not with us here. So some people may be confused that we are here on Zoom, but you would have had to register before the event to actually be with us here in Zoom. It's almost like being in the VIP room. So, but that's okay. If you're on social media, you still get access to the same information. And I went ahead and shared a link. So maybe you guys can turn on your cameras here as we wrap up. I know some of you guys were on camera earlier, and you can unmute yourselves. Maybe just give a thank you if you don't have a specific question. And Julian or Aaron, if or Julian, Maggie or Aaron, if you guys want to say anything to kind of conclude us, that would be great. Go ahead and do that.
Sure. Well, we are just ready and able to help you with any issue that somebody's coming after you for, anybody that's harassing you or your family. There is no greater remedy that I have ever found, and there's just so much freedom to be found here. So when you take that up and walk with us, we will show you a path of soft power that leads to a far greater peace and freedom than you could ever find with any argument. And Aaron here is our our right hand man for tech, all things tech related. He's an amazing technician and redesigned our whole website. He's also our outreach director, so he's a master at marketing, and I'd invite him to introduce himself and say a few words as well.
Yeah, this has been incredible. We're getting a lot of feedback already in the chat, email on the website. So this is amazing. It introduces people to what this is. A question I heard earlier is, what are you talking about? Equity has so many different meanings. Just answering that at the most basic level helps a lot of people understand what this is. And I think we need to do a better job.
Oops, did we lose Aaron there for a minute?
Aaron dropped out.
Okay. Hopefully he'll reconnect again. I know he was talking about the fact that equity.
Your audience?
Oh, there we go. He's back
There he
now.
is.
Oh,
Back. You dropped out, Aaron.
okay. So, where did I cut off?
The many
We need to do a
definitions of
better job
equity.
of,
Yeah.
defining equity.
Yeah. So, I mean, even at the most basic level. So, thank you, David, for hosting this and introducing this to your audience. This is incredible. Like I said, we're getting a lot of feedback already. So, thank you so much to the Freedom Studio and your team. I know there's a lot of behind the scenes, stuff with the email blasts and the Zoom links and all that. So, thank you again, David, for hosting this and giving us the opportunity.
Amazing. And thank you everyone for attending here and also asking great questions and keeping it lively and engaging. I appreciate you guys. I have shared the links. If you have any doubts and you're not sure where to go next, just plug into your browser thefreedom.studio and follow the links there. That has everything we have to offer, including access to this course. We are obviously offering these courses in collaboration with Standing on the Rock. We've had this partnership in place for close to 2 years, and it's my pleasure and our honor to be able to collaborate in this way. So thank you very much, everyone. We're going to wrap up there. Feel free to unmute yourself and say thank you or farewell or whatever you want to share. And
Thank
we
you
hope to
very
see you
much.
guys very soon in an upcoming event. Thank you,
Happy-
everyone.
Happy 4th of July.
Happy Independence Day.
Thank you, David. Thank you, everybody. Happy birthday, America.
Yeah.